What is hearsay evidence in a criminal case? Imagine being in court and hearing someone say, "I heard from my friend that the defendant was at the scene." Would you think that's strong enough to decide guilt? Well, that's what hearsay is all about. Hearsay evidence is when someone talks about what another person said outside of court. It's not a direct observation or experience from the person testifying. Instead, it's a second-hand statement that's being used to prove what actually happened. For example, if a witness says, "John told me he saw the defendant steal the car," that's hearsay because John is not in court to be questioned. In criminal cases, hearsay is usually not allowed. The reason is that the person who made the original statement isn't there to be cross-examined. This means the jury can't ask questions or test how truthful or accurate the statement is. Courts see hearsay as unreliable because it might be mistaken, biased, or even made up. Allowing hearsay could lead to unfair convictions based on unverified information. There are some exceptions, though. Sometimes hearsay can be admitted if it falls into specific categories. For example, statements made under stress, like during an emergency, are sometimes allowed. Records kept in the regular course of business, like hospital records, can also be exceptions. Additionally, if a statement shows what someone was feeling or thinking at the time, it might be accepted. It's also important to know that hearsay isn't always used to prove the truth of what was said. Sometimes, it's introduced to show why someone acted a certain way or to show the effect it had on the listener. For example, if someone hears a threat and reacts, that hearsay might be used to explain their response, not to prove the threat itself. For a criminal defense, challenging hearsay is a key part of protecting the defendant's rights. Defense attorneys look carefully at whether out-of-court statements meet the rules for being admitted as evidence. If they don't, they can object and keep potentially false or unfair evidence out of the case. In the end, hearsay evidence is second-hand information that's generally not allowed because it can't be tested through cross-examination. While some exceptions exist, the main goal is to make sure only reliable, first-hand evidence is used to decide guilt or innocence. This helps keep trials fair and just for everyone involved.